Welcome to today's show. Um, Today we're going to cover some topics. Today's topic is going to be two sets of parents, a mother and a father, and cherishing your time with them right now. Right now. Some of y'all been putting it off. Oh, tomorrow's going to be another day. Well, hate to be the bearer of bad news. All right. Tomorrow's another day stolen by you. All right, by you. You allowed to be stolen. The most important friends around you will show their true colors in due time. Weddings and funerals are only two events that brings out the true color of individuals. All right. The reason why I'm saying this, last month in April, I lost my sister and I both lost our mother on April 19th around 2:30 in the afternoon. I'm there for my sister and I'm her older brother. I have to be strong during this time. So, anyways, yes, I did put off, but I can't go back and change it. It's already done. I have to move forward. So today's show with Phil is going to be dedicated to the parents. Take time with your parents while you can. Tomorrow is never promised. Okay? Every child is born with two sets of parents. Take advantage of today. All right? And so today's show with Phil, I'm going to um, talk about omission from the will. All right? Now, I'm going to go ahead and put this up. And I'm going to bring awareness. And I'm going to talk about this very, very, very painful. It's very painful to talk about. Okay? This is very painful. And there are some people out there. But see, every people is represented by a tree in the Bible. A good tree bears good fruit. The evil tree bears corrupt fruit. Okay? So we're going to talk about this. This was posted January 3rd, 2018 by Albertson and Davidson LLP Contested Wills. Okay? What can you do when you find yourself left out of a parent's will? That all depends on circumstances surrounding the creation of will in the first place. For starters, in California, children do not have a right to inherit any property from a parent. In other words, a parent can disinherit a child, leaving them nothing. Minor children still be enforce child support orders or obtain a child support order for family allowance from the court where necessary. Now you see, okay, this is where the probate court steps in on this. But those to support obligation for the minor does not inherit rights. Okay. You got court orders to pay child support, but on an estate, they don't have to get nothing, according to that court. But there is no absolute right for a child to inherit property. Wow. Um, in California, that's where this will is, you know, valid. So if you do not have a right to it, inherit property from parent, and you are left out of will, what do you do? There's some chance you may take some action, whether you challenge your parent's will or you may classify it as an omitted child. All that depends on the individual. All right, the challenge. All right. You can challenge a parent's will if you have legal grounds to do so. The most often used ground for setting aside a will are lack of capacity or an undue influence. The lack of capacity must prove that your parent was not of good sound mind. In California, sound mind for the creation of the will means the person must understand the nature of his property, nature of his relation, i.e., who his children are, the general nature of his assets. The California Probate Code, Section 6100.5. This is referred as a testamentary capacity. All right. It is up to you to find the necessary evidence to prove a lack of capacity if you want to overturn a will. Wow. We're talking about a California will here. See, California Probate Code Section 6100.5 refers to testamentary capacity. It is up to you to find the necessary evidence to prove lack of capacity if you want to overturn a will. That's the first time I ever, as a Texan, that's the first time I've ever heard of somebody overturning a will. The law presumes that all people creating wills have capacity, no matter how incapacitated they may be. To challenge a will, you must have the burden to overcome this presumption to prove the lack of capacity. Furthermore, the lack of capacity must have medical evidence of a mental defect. For example, a person with moderate to severe dementia would have a medical defect that prevent him from understanding the nature of the property. If so, lack of capacity can be established, and will can be set aside. Oh, wow. So if you are successful in setting aside the will based on lack of capacity, the question becomes who receives the assets from the estate. If there's a prior will, then therefore prior will governs the estate assets will be distributed under the terms of the prior will. If no prior will, then the estate will be passed under California intestate laws, which most likely passing equally to the children. All right. For the undue influence, you must prove number one, person created will was susceptible to under influence due to things like age, mental condition, illness, and etc. The undue influencer, person doing the influencing, is in position of authority or apparent authority over such victim. Oh, wow. Didn't I say that weddings and funerals bring out the true colors in people? Yes, it does. This right here, it's important to have a testimony will, have a transfer paper. Listen, do not pussyfoot around and fiddle and fackling around and wait till the last minute to do something legally. This can come back and bite you in the ass in the long run. All right? And I promise you, during my lifetime growing up, I've seen people that were rightfully due to the estate of others got cut out with the influencer who had money and etc. Okay? I've seen this done in Texas many times. And let me tell you, funerals can bring out the true colors of individuals, so can weddings. And use the undue influence, use that action tactic, carry out the undue influence, such as isolating, controlling medication, etc. All the terms of will and trust are unfair. As with lack of capacity to undo influence requires medical evidence of medical condition that would make the victim susceptible to undue influence. And being susceptible to undue influence is different from lack of capacity. Oh, wow. I'm going to post this in the video description. I'm going to let you read this. So the omission, if you fall in the narrow category of people who are born after a will was created, you qualify as an omitted child. As an omitted child, you're entitled to your intestate share of the estate regardless of what the will states. Are you listening to this? Are you paying attention to this? So I'm already done talking about this, but the link to that article I just read will be in the description. And for the record, sit down with an attorney. Please, by the love of God, have money set aside, because the time is your enemy. I'm not your enemy, but the time is. All right? The time is your enemy. The time, the watch, the time is going. You ever look at a analog clock and see the go? All right, that second hand is the enemy. Each second passed right now is a second already written in history. It's recorded in history. And let me tell you something. Testamentary wills are important. Get a transfer paper done. Get all of that done now. Once you got to make everything. You got to get your house in order. That's what I'm trying to say. And when people sit there, oh, I'm going to play this game. Oh, I'm going to sit here and delay. I'll let them put this here. And I'm going to take the other one. And I'm going to throw, go fire. Let me tell you what. You doing that is playing Russian roulette. Okay? You get a will that is airtight. When a person passes on, you file that son of a gun immediately. The sooner you file it and probate it, when that will is stand legal and standing, then guess what? All right, then guess what? And whoever tries to file the fraudulent will, which is induced by the influencer, that will be thrown out, and the other will that you just filed that is legal and binding will stand strong. And then time will be your ally. So, today's show with Phil, I'm going to dedicate this to your parents and the will and the testament of the will, the last testament. Get the house in order and get it done legally and quit piddling, faddling, farting around, because each second ticks forward, it's a second written in history. And I'm going to tell you something. It's going to end badly. People are going to have to get up and move off. When they get kicked off the homestead, anything can happen. And let's pray that everything will come out in the end in our favors. And remember, you're going to have to take care of business. Don't sit there preoccupied with your nails and hair. Listen, Buttercup. No one gives a flying crap about your nails. No one gives a flying crap about your hair. No one gives a flying crap about where you dress. Listen to me. If you have to be in raggedy ass clothes going to the courthouse to take care of legal business, they are going to take care of you, and you're going to have to take care of the legal business whether you want to or not. You listen, thinking out emotions, it's a very dangerous thing. Thinking logically with your mind, thinking logically is the right way to go. I guess I'm level-headed is what I'm trying to say. Level-headed people get stuff done. They don't sit here and go off the wall about kids and hairs and nails and pedicure and get nails done. Listen, that's a want, not a need, okay? So, thank you for watching today's show with Phil. I hope you enjoyed this video. If you like it, smash that like button. If you dislike it, smash that dislike button. And leave me a comment below if you like this, if you like what I talked about. Now, I'm going to put the link in my description on that article. All right. And lastly, I'm not going to be an attorney for you. To seek legal advice, seek advice from an attorney, okay? Thank you and God bless. You have a good day.